Thanks, John. Hello, Unit 3. Glad to see you all. We're going to we'll introduce ourselves, you'll introduce yourselves and Peter, and then you'll get a chance to do the question that we're picking for today. So my name is Jocelyn Broman. I work in Congress for Representative Don Young of Alaska. And have worked in Congress for about 5 years. I'm also a We the People alum and also a lawyer as well. So you get all of the things that you got to deal with. So I'll let my fellow judges introduce themselves. Evan?
My name is Evan Gessner. I'm an attorney in Lexington, South Carolina. I fancy myself a civil rights attorney, and I do handle a good bit of civil rights claims, although more often than not, it's just standard tort claims, personal injury stuff. This is my first time judging at the national level, though I've been judging the state competitions for 12 or 13 years or so. So look forward to your presentation and wish you good luck.
And I'm Francine Engel. I am a political scientist and I specialize in American constitutional development. I am a judge from Maryland and I currently work with the Maryland Council for Civic and History Education.
Well, hello, judges. It's wonderful to meet you all. We are the Unit 3 representatives from Wauwatosa East High School, representing the Wisconsin Wildcard team. We are coached by Mr. Taylor McDaniel, and I'm Claire Nistler.
I'm Greta Dietzler.
I'm Gabby Duarte.
And I'm Stella Vermeulen.
Excellent. So we're going to do question 1 today. And so for the benefit of everyone, I'll read the question and then we'll let you begin. Quote, I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states, end quote. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. And what limits, if any, would you place on the practice of judicial review? When you're ready, please begin.
In modern times, the position of the United States Supreme Court Justice is highly regarded and sought after, but it hasn't always had such an esteemed reputation. Prior to the introduction of judicial review in the court case Marbury v. Madison, respected scholars such as John Jay declined positions on the Supreme Court because of the court's lack of significance and power. Without judicial review, the power to strike down legislation in violation of the Constitution, the Supreme Court was reduced to a traveling civil court. Judicial review is essential to balance the powers of the branches.
Through judicial review, the courts have examined nearly every section of the Constitution. The Commerce Clause of Article 1, Section 8 specifically has been constantly used to revise the bounds of federal power. Givens v. Ashton, the landmark case establishing complete federal authority over interstate navigation, set a precedent for a larger interpretation of federal power in the Constitution. It paved the way for a litany of decisions limiting state sovereignty. More recently, however, the Supreme Court has begun to set boundaries on the extent of federal power. For example, the 2000 case U.S. v. Morrison struck down provisions of the 1994 Violence Against Women Act that enabled rape victims to sue their rapists in federal court. The court ruled that the Commerce Clause only empowers Congress to regulate direct economic activity.
The introduction and expansion of judicial review has allowed the court space for counter-majoritarian rulings. This has prompted sharp criticism as some disagreed with the notion that the Supreme Court must interpret legislation through the lens of the Constitution, not of the majority. Clearly, these critics failed to fully understand the purpose of the court. In the establishment of the U.S. Supreme Court, the framers sought to create an entity capable of independently upholding the ideals of the Constitution that could present counter-majoritarian views without fear of political retribution. Supreme Court justices are meant to be nonpartisan arbiters of the Constitution, who don't cave to the every whim of the people, but protect the fundamental principles of government. The will of the majority is subject to strong impulses of passion that aren't morally or constitutionally correct. For example, the landmark case Brown versus Board of Education struck down state law segregating students based on race under the Equal Protections Clause in the 14th Amendment. While the outcome of this case was counter-majoritarian, it prevented future blatant discrimination from continuing and was clearly correct in finally outlawing this abhorrent practice.
There should be no limits placed on the power of judicial review because it is the sole check of the judiciary on the legislative and executive branches. It is an essential safety net which ensures the Constitution is maintained and upheld as well as putting the Supreme Court on equal footing as the other branches. As President James Madison wrote in Federalist 48, quote, "The accumulation of all powers, legislative, executive, and judiciary in the same hands may justly be pronounced the very definition of tyranny," unquote. Judicial review is not just a check on the federal government, but an important check on the states. Without the court's power to strike down unconstitutional state acts, states could disregard the Constitution by exceeding the amount of power they are allowed to have.
While the execution of judicial review is sufficient currently, it could be improved. The political questions doctrine defined in 1962 case Baker v. Carr limits the court from ruling on matters that are fundamentally political. Although a well-intentioned idea, over time this constraint has hindered the courts from answering clearly constitutional questions and from protecting the rights of Americans. For example, the 2019 case, Rucho v. Common Cause, found the policy of political gerrymandering a political question, thus rendering the court unable to rule against it. Political gerrymandering is an obvious 14th Amendment equal protection issue, and the fact that the Supreme Court cannot use the judicial review power to strike it down is unjust. The overturn of the doctrine would open the door for the court to be able to rule on political questions, but they have the ultimate say in the cases they hear, so they would not be forced to. The expansion of judicial review would be a step closer to having a Supreme Court that fully and fairly wields judicial review to defend the most important part of our government, the Constitution. This concludes our statement, and we are ready for your questions.
Very good. Let's go back to the first part of your statement. You gave a good overview of how judicial review has changed over time. What do you think has been more affected by judicial review, federal power or state power?
I believe over time, federal power has definitely been more affected by judicial review than state power. For example, in the case McCullough v. Maryland, judicial review was used to justify the necessary and proper clause and kind of expand the bounds of Congress to do more in regulating commerce. Additionally, in cases such as Wickard v. Filborn, the Commerce Clause was used to essentially justify Congress just fully regulating even what people did on their own farms down to if they could or couldn't grow wheat. And the Commerce Clause has also been used in other cases like Katzenbach v. McClung to justify integrating private businesses using the justification that segregation hinders interstate commerce. So I think over time, judicial review has mostly focused on the Commerce Clause, and it's been used to, at least historically, definitely expand federal power.
I would have to respectfully disagree. I think that judicial review has affected state powers more, as most of the cases that have been put up for judicial review have been state legislation, such as Brown versus Board of Education, and specifically South Dakota v. Dole. While it was attending to the 21st Amendment, it ultimately took away highway funding from South Dakota if they did not comply to raise the drinking age. So overall, I do believe that state powers are more directly affected by judicial review.
All right, I guess that's my turn now. Let's see. Claire, I believe you said something about justices being nonpartisan. Given the confirmation process and what we've seen over the last few years, would you agree that it's always nonpartisan, or does partisan politics come into play at some point, even on the Supreme Court?
Partisan politics definitely plays a part. We can't expect human beings to be completely non-biased when making decisions. Of course, like things like their religion and past experiences will affect their decisions as well as their professional experience. So they, I'm sorry, could you repeat your question? I forgot what you said specifically.
I was asking if it's always nonpartisan, or if that partisanship does permeate.
Yes.
Onto the Supreme Court.
Additionally, with the confirmation of Supreme Court justices, the Congress, they're shown before Congress. So even with the confirmation from Congress, there's going to be some partisanship within that because Congress is very partisan.
To add on to my colleague, the way that justices are appointed by the president has become more and more political. Presidents tend to choose justices that are more leaning towards their political background and that agree with what they want to do. And so as time and time has gone on, it has become way more politicized and polarized than it should have been. And rather than picking people picking people by looking at their background and their background on law, they pick people who would help them in their presidency.
Okay, so building on that, so once it's kind of recognized that judges can be partisan, one of the things that happens in the 20th century is we start having this notion of constitutional interpretation, and that if judges have a theory of constitutional interpretation, it will help keep them be nonpartisan and help keep politics out of their judging. How effective do you think that really is? Does a justice that has a specific jurisprudence for constitutional interpretation, like original intent or something, does that really keep the politics out of their judging?
I believe it does keep the politics out of their judging, especially because if they're firm in their interpretation of the Constitution, they're going based off of the Constitution and what the Constitution says, and not what a certain political party says, as there's a reason this is called originalism, modernism, textualism, precedent setting, and not a Republican interpretation of the Constitution or a Democratic interpretation of the Constitution. Additionally, the supremacy clause in Article 6 has been where judicial review has been derived from, and I think that's really important because it illustrates justice's commitment to interpreting based off of the Constitution and not what politicians want. Additionally, Article 3, Section 1 outlines life terms for justices, which makes it easier for them to interpret the Constitution the way they see fit, as they don't have to please a particular party to stay in office.
I disagree with my colleague. I believe justices should be interpreting the Constitution with a more modern lens. As the Constitution was written over 200 years ago, the framers left the revisions of Article 5 of the amendment process to allow for further amendments to be added. So I believe with their intentions, they would have wanted the Constitution to be interpreted more modernly and as the times go on.
But so in your statement, you guys made the argument that you wouldn't want to put any limits on judicial review. If the process remains as partisan and the confirmation process remains as partisan as it has been in the past few times, wouldn't it make sense to put limits on judicial review or put term limits on the justices to make sure that the partisanship doesn't seep through?
Not necessarily. I still believe that there should not be any limits on judicial review, except for I think that the political question doctrine should be opened. I think there's this sort of mentality that by not answering political questions, it kind of pushes down that partisanship. But I still believe that talking about these cases and opening them up will make sure that there are constitutional matters that may be seen as political that still have constitutional basis, such as Roto v. Common Cause, which is clearly a 14th equal protections amendment issue. So even by limiting them, I still think that it wouldn't really matter regarding the partisanship, because you're always going to have some type of partisanship because of the Article 2, Section 2 appointment powers, because of the way that presidents tend to appoint justices that lead towards their political background. So I really don't think that adding any limits would really change that in any way.
To add on to my colleague, I do think that creating term limits for justices is a good idea. As we see in the UK, they have term limits for their justices until they are 75 years old. I think that's a really good idea because it cycles in judges and creates more a wider range of points of view. And I think that's a really good idea to keep things moving and to keep everything more modern.
Well, that was perfect timing. So good job, everyone.
All right. Well, we want to recognize the students for their hard work and the participation today. So let's all give them a round of applause.
Yes, they're great. We'll do some feedback real quick. I liked your statement, how it opened up and you followed through and like answered all your questions. I wish I had thought to ask more about the counter majoritarian and independent views versus constitution, because that's always fun, because it's like, yes, we want, like, as Gabriella was saying, like interpreting the Constitution in a modern lens, but how far can it go and how does that kind of look at? So I wish we could have explored that a little bit more. You guys had some great examples and good references to one supremacy cause for talking about federalism. And then, yeah, in regards to like my first question, what I was hoping to hear is where had power been limited and where had power been expanded? So I would have liked a little bit more detail on the answers to like, where did judicial review like really start impacting things? You guys did a good answer, but I've liked a little bit more detail to kind of like walk me through it a little bit more. But otherwise, it was a very good presentation, everyone.
Yeah, really great job. As I said earlier, this is my first time at the national level. My previous experience being limited to the state competition, where I think there's a bigger difference in the teams. Here, I expect the competition to be much closer. So I'm going to have to figure out how to score everybody accordingly. I thought y'all really did a great job. You know, this being the second time I'm doing this by video conferencing. I know it's usually when I do this in person, sometimes you'll see people when they'll read their statement, they look down and they're reading something and it seems robotic, and it's better when somebody looks at you and talks. But here on Zoom, it's a lot better because you can have it on your screen next to you. And even if you're reading a script, you're looking right at me. So that's a big difference I've noticed here today. No, I thought y'all did great. You're great even participation. You'll clearly know what you're doing. Yeah, I'd ask a question about partisanship in the Supreme Court, and just as a practitioner, I would say what I've noticed is the partisanship really comes down to one major thing, and that's sort of the strict constructionists and the conservative end versus the more liberal application, kind of how does this work today? And I could say that works with judges from the state trial court level all the way up the courts of appeals to the federal government, that's where the difference lies. But if you talk about one particular issue at any given time, when that judge is going through the confirmation process, over the course of their career, that winds up to not really be an issue. And if you look at, for example, Chief Justice Earl Warren, you know, when he was appointed, I think Eisenhower appointed him. I don't think he ever would have envisioned what Earl Warren would go on to do. So there is certainly some partisanship, but I don't know that it has quite as much of an impact as everyone might fear. But again, great job. Thank you.
Yeah, I thought you did a fabulous job. I really like how you started off your presentation talking about how the court initially really wasn't that well respected. And I like how you brought up the idea with John Jay, how he actually declined a position on the Supreme Court because, you know, it was more prestigious to be in state politics than national politics, particularly on the court, because the court just really didn't have much power until judicial review comes along. You did a great job, I think, talking about the importance of the Commerce Clause in there, how that is brought about national powers taking powers away from the states. You brought up a lot of good court cases, for examples, U.S. versus Morrison. You had South Dakota versus Dole, Katzenbach, Baker versus Carr. And yeah, so I really enjoyed that. I wish I had a chance to ask another question because I was really interested in what you were talking about with the political questions doctrine. And I guess what I'm wondering, what I wish I had more time to ask you is, what do you think the difference is between a political question and a legal question? You know, they kind of have that definition out there of what the difference is, but you know, whether or not they see it as a political question or a legal question often is very partisan itself in terms of how they decide to interpret it. And the cynics of the court will say, well, you know, if they want to get involved in the question, they call it a legal question. And if they don't want to be bothered, they call it a political question and just kind of get rid of it that way. But it's just a really interesting question in terms of the role politics may or may not play, and whether or not things like constitutional interpretation can actually try to limit those issues. But I thought you did a fabulous job. I really enjoyed hearing what you had to say. And what I really, really liked is that not only did you all participate, but that you had different points of views. And so somebody would say something and you would say, I disagree with my colleague. And whether or not you actually really did, or if you just did that to get the other point of view out there, it was great, because that's really what you need to do, is you want to show that you understand both sides of an issue. And so I applaud you for doing that, and recommend that you keep doing that in future competitions. Thank you so much.
Thank you so much, judges.
Excellent job.
Great job, everyone.